Happy Friday Night Live on a Thursday with whiskey. I got a new whiskey ice cube and my light is reflecting off of this glass so much you can't even see it. I'm so sad, but I'll have to post it on Instagram. It's very cute. But that's what you get when you have iridescent whiskey glasses because it's just like that. It's just like that. Welcome, welcome, welcome. It's so good to see you, Lawnards. It's been a week. It's been a week. I got a haircut. We freshened up the color a little bit. I used to have a gray streak before I was dyeing my hair, all kinds of fun colors. So in homage to the gray streak that still lives there, I decided to go full like X-Men. So I'm living for it. I'm embracing my inner law nerd and my inner nerd, and I just love it. So that is where my gray streak normally is, and we just did it. So tonight is going to be a chit chat. We have a couple topics. I kept changing. If any of you were in the stream earlier, if you're members of the channel and you're in the pre-party chat, you will see that I kept changing the title of the stream and kept changing the thumbnail of the stream because I was like, no, other stuff happened. No, I don't want to talk about this. No, I want to talk about this. There's new court rulings in the Josh Duggar case on all those motions in limine, and we've covered so many motions. I feel like we all need resolution. I need to be resolved. I've been streaming a lot this week and really looking at the Rittenhouse case fairly closely. I'm going to talk about stuff that went down yesterday and what I think is coming next based on my experience as a district attorney for over 10 years, based on a lot of jury trials and just based on what I'm seeing and the notes coming from the jury. And then we're going to talk about this motion to seal in the Britney Spears case that I haven't gotten to talk about this week. And then next week, we're going to be talking about Tiger King. There's still no court ruling. Tiger King got released, so Carol Baskin already kind of lost. She wanted it not to get released. That ship has sailed. It's been released everywhere, and I can't wait. So let us just get into it. If you are new here, go ahead and let me know with a 1 in the chat. Let me know where you're coming in from, what you're drinking. Let's do all of the things. Let's just do everything. I'm declaring it Friday. It's Friday in my mind because tomorrow's a day. So let's go. Let's roll. You guys ready? Let's do it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. I don't dislike Carol Baskin. She look, I don't have any ill will towards Carol Baskin except her lawsuit was so rambly that it gave me a headache, and she already lost. No ill will to her. She tried to stop Tiger King from getting released and it didn't happen. So no ill will towards her at all. I think the hate and harassment that came her way is awful. But also her lawsuit was funny. And we have to be able to make fun of something. And so right now, it's Carol Baskin's lawsuit. That's all we got. Gina, welcome to your live for the first time. Before we get into it too much, replay crew, love you. There will be timestamps down below, and it will be what it will be tonight because it's already like that. I've recorded a lot today because I've recorded a lot today. Like a lot. Like a lot. So tonight I have a very nice ice cube. I love it. I got a new round one. We got a new whiskey glass. It's like Christmas came early. When I start shopping for Christmas presents, I buy for myself way too much. I don't know if everyone else has this problem, but this is a problem I have. And so I needed new whiskey glasses. Not really, but I did. So I got them. We're drinking salted caramel whiskey tonight. It feels very nice on the voice. Last week was a champagne stream. That was a whole thing. That was a lot of fun. I really enjoyed getting to celebrate Britney being free with you. It'll be interesting to see what's going on because there are new motions there. So thank you all. I will always take all the compliments. I appreciate it. The hair is it's fun, right? It's fun. It's fun. There's also stuff going on in the Activision lawsuit that I have to catch back up on. It's been so much. You guys, it's been so much this week. I'm tired. I really am. And it's been, if you guys were here for coffee and Cursey Words on Tuesday, you know it's also been an emotional week for me. And the thing that I am constantly learning as an adult is emotions also take energy. And so when emotions also take energy, being tired can be a lot. Allie asked a very relevant question. Here's why I love drinking Vouv. Vouv doesn't tend to give me a headache. I don't drink champs a ton. Whiskey also doesn't give me a headache. And I take like charcoal and glutathione and other stuff to support my old body in processing alcohol. I did not have a headache at all. I was tired, but I did not have a headache. So the hangover was not bad at all. So we should add champagne stream to the thing. It might need to become a members only perk. It's like, hey, we're doing a champagne stream. Sadly, there will be no law nerds tonight. The law nerds are at Kitty Condos already because of travel plans, upcoming travel plans early tomorrow. So unfortunately, the law nerds are gone for the night, which always makes me so sad. My first live watching with my new kitten, Lucy Ricardo, and I love the hair. Well, welcome home, Lucy Ricardo. We love a kitten. What does salted caramel whiskey even taste like? It tastes like butterbeer. That's what it tastes like. That's what it tastes like. That's what it tastes like. So, Earthbound in Spirit, I see you in the chat. I'm sending my heart to you. It zoomed by and I couldn't pull it up, but I'm sending you my thoughts. Emotional exhaustion is real. And we're going to talk about emotional exhaustion for sure when we get, well, in next week's podcast, because I talk about the new lawsuit filed by Gloria Allred in the Rust tragedy, and intentional infliction of emotional distress is in there. If you guys have questions, we'll be able to do questions down the road. And when we open up questions, we're just going to open up to all topics and we'll get to what we can get to. During the topics, I try to keep the mods help me keep the chat on the topic I'm talking about. Because I am ADHD, I try to create a streaming environment that works best for me. And that includes the chat kind of being on topic with what I'm talking about. Otherwise, I will scroll and never get back to what I was talking about. And then the rest of you are like, but you were in the middle of a thought and you haven't finished the thought, and I am unresolved until the thought is finished. And that is why, one of the reasons that we do it that way. So let's talk about Rittenhouse first. I'm not going to do a weekly roundup. There's so much that happened in law this week, but you guys know, A, that I am a little bit exhausted on the personal side, and B, I've really been watching the Rittenhouse case closely and absolutely been streaming a lot, and then covering the Britney and Duggar stuff. So that's what's going on. So let us talk about that before we get into it, and I swoop it. For those of you new to the stream, hi, there are rules here. I know, especially on Tuesday, talking about this case got very polarizing. I understand that this trial is very polarizing, but the facts and talking about facts and procedure doesn't have to be polarizing. So that is why the mods are really helpful when I have instituted rules like we don't name call. We're not going to spread rumors and misstate information. We're just going to go with the facts that have come out in court and then my opinions, because they're my opinions. I understand that everyone has their own feelings. You're welcome to your feelings. Your feelings are totally yours. I am here to just talk about the facts. The facts can be very frustrating. The procedure can be very frustrating. And I totally get that. And it can feel like fuckery. And that's why we're going to talk about it. Because if we don't talk about it, then it's all just like, I fucking hate this. Why is it that way? And I don't think that that's a very empowering position to come at the world from. So we are going to just jump into it with that caveat and knowing that the rules come from me on my stream, because that's what the law nerds are about. We're about talking about things and having conversations and talking about the facts and not the fuckery. And there's a lot of fuckery in the Rittenhouse trial. Like, just the lawyers, there's so much fuckery. So much fuckery. Hey there. That's the wrong button. You're like, wait, are we starting over? Nope. It's going to be that kind of a night. That was just the wrong button. If you want to know if I produce my own show, yeah. Tech Valor helps me, but yep, absolutely do. So, with the Rittenhouse case, the jury is still in deliberation. I am not surprised that the jury is still in deliberation. I think this is a jury that is indicating that they are going to hang. The term hung jury is a weird term to me. I have not vetted the like background of why that's what we're talking about. I don't know why that's what it's called, but it's a jury that can't decide. In criminal cases, you have to have everyone agree on every single step of the way. And the jury instructions for the jurors and the verdict forms are substantial because there are lots of questions. The questions before the jury are, what is is this charge a homicide or not a homicide on the degree that they charged it? And I'm not going to try to break down each degree because some of them vary and I don't want to say it wrong. And then if yes or no, and if it is, because all of them are homicides, they were lives taken at the hand of another, is that a justifiable homicide, meaning there's a defense to it? Is that defense self-defense? If there's self-defense, was that defense lost because of provocation, meaning that the person initiated the fight? That's normally not something we see in a situation like this. We normally see it in like really aggressive provocation, but that doesn't mean that the jury might not find it. The prosecution argued it. I don't agree with all of their arguments personally. They argued provocation. A jury can say, yes, it was self defense, but you lose the self defense, or it's imperfect self defense, or it's a lesser charge. So there's lots for the jury to go through, but it seems that they are stuck fighting on these jury instructions. At first, they asked for the jury instructions they asked for a copy for each of them. I don't know why they had only sent one copy back. Normally, each person gets a copy, but they sent a copy back, and then the jury asked for all of the copies. So one copy for each member of the jury. So 12 copies in total. They asked for some of the video. They asked to look at some of the video. And then today they asked to be able to take jury instructions home, which is mm, which is staggering to me. Like jurors normally aren't allowed to take their notes home. Normally they don't even take their notepads out of the courtroom. They have to leave the notepads in the jury room. In the trials I've done, and I've only done trials in LA County, in the trials I've done, you have the jury take notes in their notepad. The notepads stay on their chair and then are collected by the bailiff and locked in the jury room. Nobody touches them, nobody messes with them, they don't go home with them. It's very odd to me to see a jury not just request that jury instructions go home, but for it to be allowed for jury to go home. And I'm just like, well, what? Why? Because the only reason a juror wants to take those home is to sit and talk about it with somebody else. And that's exactly what they're not allowed to do. They're not allowed to sit and talk about the jury instructions with anyone else. The jury instructions are meant to be discussed with the jurors that are deliberating only. That's it. You can't take them home. It's the strangest request. I can't understand why that would happen, but this is off for me and it's strange. It's very strange that this would be a request, and I feel like there is probably one or two people that are holding this jury up one way or the other, and we don't know. The questions indicate to me that there are a few people holding it up, leaning towards guilt, that the people who are hanging it up are leaning that way. The reason I think that, and Viva Fry actually brought this up when we were on stream today, and he made an excellent point. And this is the one thing I really love the most about talking to other attorneys is they catch on little things and then you go, yes, and this. And so you can break down the pieces better than this. So um, have you tried mead before? Mead, the drink mead? No, I have not. Mead sounds amazing and old-timey, but I have not. Do you see how easily distracted I get? I was trying to pull up Viva's Twitter because he posted the question from the jury that we were talking about earlier, and this was one of the last questions. And I thought it was a very helpful insight. Of course, my screen's already shared. We're professionals here. By that, I mean it's not already shared because we're professionals here. Because why wouldn't it be? This is a question from, is today the 17th? Is today the 8th? What day is it? Today's the 18th. So this is a question from yesterday. The highlighting was from Viva himself, but this is the note that came in. Please prepare Mr. Rosenbaum shooting event 1, FBI aerial with all POIs marked. That's people of interest marked. That's the one that had the little triangles and circles and squares. Drone video zoomed in something still after. So zoomed in something age still after Mr. Rittenhouse put down fire extinguisher, full event, one video in regular and slow motion. We will request when ready. And then who the presiding juror is by juror number, the date, the time. So this was yesterday morning. The thing that Viva pointed out was that, image. You guys are saying it says image, zoomed in image. Thank you. Look, this is the writing in the background is hard when you are dyslexic to parse those letters. So thank you, zoomed in image. I appreciate the chat. This is why I pull things up. This is why I pull things up on the screen so y'all can work with me. So zoomed in image still after Mr. Rittenhouse put down fire extinguisher. The reason that this became a conversation is because the prosecution is the one in their closing that kept saying that Rittenhouse put down or gently put down the fire extinguisher, where the defense's recitation of that was that he dropped it while he was running or threw it while he was running. So just that use of language shows you which attorney this juror is cueing off of, which language they're using. And that can be unintentional on the behalf of the juror, but it means they've adopted that view of the case. The fact that they're saying put down versus dropped means this juror that's writing the note is adopting the prosecution's view of at least this incident. And if they're adopting the prosecution's view of at least this incident, they might be asking for that footage to try to convince other jurors onto their side and to try to clear things up. So it really is highly relevant. We were talking also about the tone of this. I think a lot of us interpreted the tone differently. Some interpreted this tone as being pushier or bossier or more entitled than others. That's all up to interpretation. I invite you to interpret it yourself. So I really think it's interesting seeing that from the presiding juror or the who's in charge of kind of deliberations. I have had a presiding juror be the one hanging juror. I've had a number of hung juries. I've had the presiding juror be the one juror that hung. 11 for guilt, because I was a district attorney, 11 for guilt, 1 for acquittal, and that one juror was the presiding juror, and it hung my jury up for days. And by the time the jury came back and delivered the verdict, the 11 that were on the other side were like this, and they were arms crossed, and they were pissed. And when we dismissed the jury and declared the mistrial, afterwards, the jury was like, this juror would not listen. They wouldn't deliberate. They wouldn't do this. They wouldn't do that. And they were so frustrated. That can be going on in this jury room too. That the jurors are like, you can show us whatever you want. We don't agree with you, which is why I think this is going to hang on all of this. I've also had 2 female jurors hang a jury the other way when a lot of people were leaning towards acquittal on a case that I felt very strongly about, that there were 2 who were like, no, I believe the victim. I believe the witnesses. This is not a not guilty. There are other things at play here that are swaying this jury. And we ended up retrying that individual, and they are serving life in prison without parole. Well, at present, unless George Gascon changes his mind on that, for the murder of a witness in a case. So a special circumstance lying in wait case. But with that, the language that's being adopted here is very interesting. I think this is going to hang. I don't know if when it hangs, if the judge will then declare a mistrial with prejudice. There is so much that this prosecution team has done that is not just improper, but grossly improper and egregiously improper, that the judge has room to do that. I don't know if the media coverage has influenced the judge or made the judge more cautious, or if the judge has always been cautious this way. The judge, I believe, is in his mid 70s. Most judges in their mid 70s are fairly set in their ways and generally aren't swayed. But then again, the judge has really talked about the media a lot and then banned MSNBC from the courtroom today after it seems that a reporter or a freelancer with MSNBC was pulled over after running a red light last night. Believed by the police or relayed to the court by the police that they were following the jury bus, and there was concerns that he was or that individual was, I don't know their gender, the person who was driving the car, but that they were following the jury perhaps to get photos of the jury or something like that. The bus is a closed bus, so it has, the windows are blocked out, and the judge said, well, so that the jury can't see things or see the protesters. It's also so that you can't see them. I can see the chat asking, what does with prejudice mean? With prejudice means it cannot be refiled. Normally, when there's a mistrial, the mistrial will mean that it can be retried. So if they hang 11-1 for guilt, you can retry it. If they hang 11-1 for not guilt, you can retry it. You do it again, the whole trial, start to bottom, new jury, later, and you start over and do it all again. But if you grant the mistrial with prejudice because of the behavior of the prosecution, and there are limited circumstances where you can do this, then they can't retry it again. Then the case is dismissed on these charges. They can't retry it again. Double jeopardy applies, and it's done. Kyle Rittenhouse is no longer charged. He retains his presumption of innocence, which everybody goes into a trial with, presumed innocent until found guilty, and that is it. So that is it. The defense has made some interesting choices in this case. I don't know what their client is telling them. I don't know what their decisions are. I would have objected more if I was them. Again, I would have lost my mind with what the prosecution's done. There's been so many missteps. I think the judge can dismiss this. So I won't be surprised if the judge dismissed it. I won't be surprised if the jury hangs. I think when the judge uses words in court like, this case is built on a house of cards based on that drone footage, and then the drone footage was not turned over to the defense in the proper format, that's a huge violation of the rules of evidence. And the prosecution shouldn't be allowed to play fast and loose with the rules, because even if a lot of you or any of you are sitting there going, I don't care what the prosecution did, I think he should be convicted, there will be a defendant down the road where you're like, this is grossly unfair. Why is the prosecution doing this? We need to make sure that prosecutors in this country adhere to the rules, because it protects those who should not be convicted. And it has to apply to every single case, no matter how popular or unpopular the defendant is, because then you end up with a situation like Bill Cosby, where the prosecution didn't do what they should do. He gets convicted. Yeah, great. He goes to prison. Yeah, great. And then it gets overturned on appeal. And everybody's like, wait, what the fuck? Exactly. What the fuck? And then you're like, well, they should have followed the rules. Exactly. They should have followed the rules. And that's what's really frustrating. So we will see what happens. Tomorrow's Friday. So Fridays, juries tend to get a little squidgy. I will be very interested to see what they do. We're also coming up on Thanksgiving week. So we might have some more information from them tomorrow. We might have more wrangling by the defense tomorrow. I, on a personal note, this is only partly joking, assume that because I'm getting on a plane, shit's going to go down tomorrow. That's always the way it's been. And that's what it is. So you guys see that I have Lady Justice. Lady Justice was given to me by my grandfather when I graduated from law school, this particular Lady Justice. Lady Justice has a blindfold and scales, because justice is supposed to be blind to who the defendant is. And I think everyone wants our system to get back there where it doesn't feel like certain defendants are picked out and treated inequitably. All defendants who come before the court should be treated equally and fairly. And it's a problem that they're not. And treating this defendant being like, well, we hate this guy, he sucks, so whatever, the prosecution did whatever, but we like the result, isn't the way we get to a system that treats every defendant fairly, no matter what. And that's the system that we're supposed to have, where justice is blind and not outcome determinative. And I mean, that might sound naive, but that's the reason that the system is the way that it is. It's supposed to treat everyone in the chair, in the defendant's chair, as if they are innocent until proven guilty, and they can't be proven guilty in violations of their constitutional rights. And if our system isn't working that way, our system isn't working, and people who shouldn't get convicted get convicted. And that's not right. And that's not really about the Rittenhouse case. That's about our system as a whole. And our system as a whole should work. So that's what that is. We are going to be getting into, and those are my thoughts, and the MSNBC stuff, I don't know what's going to happen with the following the jury bus. I think putting the jury in fear is appalling. And hopefully it makes the jurors mad. And the facts of the fuckery that's gone on in this case are things that should never have happened. I think the judge probably should have granted a mistrial well earlier than this. And it's going to be real interesting to see if he doesn't. I saw a really good question from Matthew and it caught my eye. So we're going to go with the gut and we're going to grab it. Is it possible for there to be a verdict on some charges and hung on others? It's absolutely possible for that to happen. It can happen that they can acquit on some charges, they can convict on some charges, and they can hang on other charges. If that happens, if there's an acquittal or a conviction on some and a hang on others, the case only goes forward as to the others that weren't decided, or they get dismissed. So that's really what that is. So yes, yes. So that. All right. Let us just move forward. Kitami said, I love you, Emily. Thank you for not just jumping on the prosecution side. I'm really angry at this prosecution team and actually seeing the whole situation. The point of being a good lawyer is to see the whole situation. And then when you're in court to advocate for your side, I feel like my role as a commentator is to show you how I think on both sides of an issue, to talk through how I see things on both sides of an issue, to tell you how I determine where the facts lie, what my process for parsing things is, and then to either tell you how I feel about it, to not tell you how I feel about it, to let you make up your own minds, and to make jokes where they are appropriate, and to call out fuckery where we see it. That's what I think. So yes. Me going, I'm going to move on and then not moving on. Yep. Okay, can you go over Brady rules and violations? I think I understand them, but I'm not sure. We're not going to do a whole lesson on Brady, but in short, the Brady case, and that's why it's called Brady violations. You, as the prosecution, you have to turn over all evidence that can be potentially exculpatory to the defendant. That means if there's a police officer that has a disciplinary record, you have to give it to the defense. If there's a video, you have to give it to a defense. If it might have been the Brady case. I am not good at remembering cases and facts together. I remember the facts, but I never remember the name. There was a case where there was a coat that was checked into evidence, but there were things in the pockets of the coat. There was like a receipt and maybe a note, but there were things in the pockets of the coat. The defense only got the photo of the coat, that the coat had been checked into evidence, but not that there were actually things relevant in the pockets of the coat. I don't think the prosecution knew that they were there in that particular case. It doesn't matter. The police had the things in the pockets in their possession and they were obligated to turn it over. And that case got dismissed because the things were not turned over. They have to turn over anything that can potentially be exculpatory. As a DA, I read that to be, if I have it, they have it. If I have it, they need to get it, unless it is stuff that's redacted out. Sometimes you redact out a witness's address and say, we will make the witness available to you to be interviewed here or at another safe location. But you had to let them know that there was a witness, what they were going to say, and at least what their initials were, and then let the court know you were redacting out their information. So you have to turn over everything you have. It's not like civil discovery where you go back and forth in emails and be like, well, I'll give you this, but I'm not going to give you that. And I'm not going to tell you how much we charged Britney Spears. We're not going to tell you how much money we took from her. We don't have to. Let's make us go to a deposition. Fine. We won't show up. In criminal discovery, if the prosecution has it, they turn it over. And if the police have it, it's deemed that the prosecution has it. Even if the prosecution doesn't know about it, they can get in trouble for not turning it over if the police have it. You can't be like, oh, well, the officers had it. I didn't know. It's your job. You have to turn it over. And turning over a lower grade quality of a video is not acceptable. It's not acceptable. There's so much that's not acceptable. I'm shocked. And you hear defense attorneys go, well, the prosecutors do this and the prosecutors do that. I worked with really ethical prosecutors. There were times I saw stuff in my office and everybody went, "Wait, don't do that." And most of the time it was mistakes of attorneys that didn't think, didn't know, whatever. But when you see it in real time like this, it's chilling because constitutional violations cannot be taken lightly. And the cases I've covered this last year have been heavy and they've been chilling because it's a lot of attorneys doing fucked up shit that they shouldn't be doing. And it just, but we're moving on. We're like 30 minutes in, and now I'm like, we're getting all mad again. Emily, stop getting riled up. Start getting riled up. We need to move on to talk about those Duggar rulings. Before we talk about those Duggar rulings, though, we're going to say thank you to today's sponsor, NordVPN. A huge thank you to today's sponsor, NordVPN. You know that I've been working with Nord for a while now, and this time of year, I'm particularly thankful that I have a NordVPN. And you are like, what's a VPN? A virtual private network helps encrypt your data as it travels out through the interwebs, not only so you don't get those annoying pop-up ads because you looked at that one thing that one time on the interwebs and then it follows you everywhere, but also to make sure that your financial data is secure as you are sending it along. And I don't know about you, but for me, 'tis the season to shop. And I want to make sure, that when my kids use my computer, they don't see what I've been searching for them for the holidays. So I don't want those ads popping up and tracking me around. But I also want to make sure that when I am paying for things and checking out on websites, that my information is being securely transmitted. And that is one of the things I rely on for NordVPN. But when my kids are on their devices, I can add Nord there too, especially with our travel coming up. We're going to be on some hotel Wi-Fi, and I want to make sure that even though hotel Wi-Fis are not secure, that my devices and my kids' devices are secure by using that virtual private network. You can use Nord on up to 6 devices, and it can be your iPad, your computer, your laptop, your phone. And I really appreciate having those options, particularly for me when traveling, when I'm on those unsecured, complimentary Wi Fi. It's not complimentary if they take your information or if somebody accessing that Wi Fi can do it. So I highly recommend a VPN. You know, I highly recommend NordVPN. And right now, during Cyber Month, you can get a huge discount on 2 years plus an additional month when you use code Emily D. Baker at checkout. That's right, nordvpn.com, Emily D. Baker. Use the code or just hit the link down below, however it works for you. nordvpn.com/Emily D. Baker. And if you've already signed up for Nord because I've been working with them on this channel, let me know how you're enjoying it. All right, we should get back into the legal stuff. And we're going to swoop right back into the Duggar stuff. I know it was like a flash from the past. For all of you catching me live for the first time, you're like, your hair is very different. Yes. Yes, I pre-record our sponsors and I appreciate them so much because they help me be a full-time content creator and do what I do, boo? All right, let's get into Duggar motions just by way of a quick reminder. There are multiple videos on this. There are numerous pending motions from Duggar, who filed a bunch of motions in limine, and the government filed a bunch of motions in limine, not in lemonade. I saw that comment. I think I say it so fast that it sounds like lemonade, but maybe we should just call it motions in lemonade. The sour face motions, like, I don't want you admitting that evidence at trial. Maybe they should be motions in lemonade. Maybe. Do you think? So the motions in limine are the pretrial motions that talk about what evidence can be presented at trial, what can't be presented at trial, put some boundaries around it. And now we've got a ruling from the court from yesterday. Hey, look at that. Let's see what happened. Let's see if I was right. So you were like totally thought it was lemonade. Motions in limine to limit the things. Law. I think motions in lemonade are, and we also get like Beyonce vibes when we go motions in lemonade. It's just like, it's just motions in lemonade. All right. The motions in lemonade, better than not deleting your shit, maybe, kind of. The motions to not admit this shit into trial, or the motions to admit this shit into trial. This is the order of the court. I like this. I like the writing of this judge. It's always been snappy. This is my first look at this. I haven't read this yet. So we're going to do it together with whiskey because why not? Um, we've got to do it. Thank you, Purple Glitter Tears, for sharing. Defendant Joshua James Duggar was indicted on April 28th on counts that you know: receipt of the CP, possession of the CP, and a forfeiture allegation. Forfeiture means we keep your shit. Pending before the court are the following ripe motions in lemonade. Oh, the lemons are ripe. Here's what it means when things are ripe and juicy judicially. It means they're appropriate to be decided before trial. We talked about this on Tuesday. Some of these motions, it's like, well, if it's relevant, then it's relevant. And it's not relevant, then it's not relevant. It might not become relevant till later. And if it doesn't become relevant till later, then we can't rule on it now because it's not ripe yet. So that's what ripeness means in the legal term. Not that the lemonade is going to be super extra juicy, but don't we love juicy lemonade? So the ripe motions are the government's motion concerning trademark inscriptions. Well, this one wasn't super juicy. It was like it's an HP because it says it's an HP. The government's motion in limine to admit prior statements made by defendant. Ooh. And defendant's motion. The devotion. Yeah, we're going to get to the Ashley Madison shit in a second. The devotion is not there. Defendant's motion in limine to exclude evidence of allegations concerning adult and or prior so-called addiction to adult content. We're going to go with content because yellow. So those two are very interesting. I'm so glad the judge ruled on those. I can't wait to see what happens. Let's all find out together. The government's motion to exclude third-party guilt evidence. I'm curious about that too. Defendant's motion to exclude improper opinion testimony. That's moot essentially because the attorneys all said, yeah, we're not going to do that at all. Defendant's motion eliminate to sequester witnesses pursuant federal. Yeah, that's just going to happen. Defendant's motion eliminate to exclude any reference to defendant's stated decision declining to answer. And the government said they weren't going to elicit that either. There are some missing. And the most notable one that's missing, and I'm going to pull up my list real quick of all of these motions because I actually have a running list of each case that I cover. Oh, wait, don't do that. I'm going to lose my notes for now. Ah! No, I have a running research document on each case that I do. So I want to see if there's any more missing. But the notable one is the prior conduct with regard to the hands-on essay of minors, mostly his sisters. That is the big one I don't see. What else do I not see? I don't see the corporate records being ruled on, and that was a government motion. So those are the two I don't see. The corporate records and the juvenile allegations. Those are the two that I don't see. So the court is saying in this that those are not ripe yet. The prior allegations of SA on minors is the really big one here. But getting to the addiction and prior adult content ruling will be very interesting. So me saying it's going to be interesting and y'all going, we'll decide what's interesting. We will decide. Government's motion concerning trademark inscription. Accordingly, it's ordered that the government's motion is granted. Well, a laptop's a laptop. The government seized an HP desktop from the defendant's business and intends to introduce this computer as evidence. A trade inscription on the computers indicates that it was made in China. The government contends that the computer is self-authenticating as to its origin. Yeah, it's a computer. It's made in China. It's an HP. Granted. Government's motion to admit prior statements and defendant's motion to exclude allegations concerning adultery or a prior so-called, quote, addiction to adult content. The government has said they're not getting into the Ashley Madison stuff, which is the adultery allegation. It might come up if defendant testifies as to character, but he'd have to kick that door open with a wrecking ball, and I don't think he'll do that, but you never know. You never know. The government and defendant each filed a motion concerning similar subject matter. The government's motion asked the court to find certain prior statements defendant made in a 2015 social media post to be admissible. Defendant allegedly stated, quote, I have been the biggest hypocrite ever. While espousing faith and family values, I have secretly over the last several years been viewing pornography on the internet, and this has become an addiction. You know, You guys brought it up in the chat, and it came up in the comment section on Coffee and Cursey Words. He doesn't say adult pornography. I think it's an assumption made because CP is illegal and you wouldn't go on social media and admit to doing something illegal. But I think it bolsters the government's case, but I don't know what the court rules yet. So let's keep going. According to the government, defendant's statement regarding this addiction is admissible under Rule 404b2 because it tends to show his motive, intent, knowledge, or plan. The government also views it as the only possible reason why Covenant Eyes was installed on the HP. And this is going to be critical to the partitioning of the computer. For those of you new to this case, Covenant Eyes is a anti-adult content addiction program, and it shows what you're looking at on the internet to your spouse. Does this work with shopping? Like, not to make light, but to make light. If I'm shopping on like Vuitton's website and I'm seeing things I really like, can there be a program that just sends those links to my spouse so that they're never stressed about what to get me? It's like, hey, your wife would like a new diamond cartilage earring based on her web searches. Can we do that? I need that program. If anyone knows of that, let's make it happen. I think that's a great idea. I need it. I need that the most. Okay, but back to using computer programs to break P addictions by sharing what the person's searching on their internet with their accountability buddy, who in this case is Duggar's wife. The government describes Covenant Eyes as a computer program designed to help an individual overcome an adult content addiction. We're moving on. We've seen it. The CSAM, which is the definition of the possession of the illegal CP, the CSAM that are at the subject matter of the charged conduct in this case was located on a partition of the HP desktop hard drive that could not be detected by Covenant Eyes. That is really relevant to this trial. The government reasons that the defendant's motive for creating the partition on the HP computer was to mask the downloading and viewing of the material from being detected and reported by Covenant Eyes. Therefore, the government says it all needs to come in because otherwise it doesn't make sense. Further, the government believes that all these facts and combinations, the addiction, the installation of Covenant Eyes, the location of the CSAM on a partition section of the drive establishes the defendant's identity as the person who committed the charged offenses. Remember, in a computer crimes case, which this is, you have to show that the person that did the thing was at the computer doing the thing. You have to prove it. This is one of the ways the government wants to prove it. Unsurprisingly, I like this judge. And I like this judge from the writing. The way the judge writes the opinions is very human. I love it. Unsurprisingly, defendant moves to exclude all statements or allegations that he was or is addicted to viewing adult popcorn. He also, I've already said it. I don't know why I'm getting around it. We're going to just say every P word we can think of to get around it. And then I'm still going to say it and we're still going to end up yellow because whiskey and it doesn't even matter. So I love y'all. It's just whatever. He also moves to exclude any mention of the fact that he might have committed adultery in the past. He explains that he posted no, they don't admit that he posted it. They say it was posted to his family website and they kind of allude that somebody else might have posted it. Like, I don't know, Jim Bob or somebody, just allegedly. He explains that he posted the 2015 social media statement about being addicted to parsnips to minimize the public relations fallout from the embarrassing revelation that he was allegedly a member of the website called Ashley Madison, which catered to consenting adults seeking to engage in extramarital affairs. He contends that that his alleged involvement with the website and subsequent admission that he might have been unfaithful are facts irrelevant to what's charged. The government agrees about Ashley Madison, so we're going to move on. In the defendant's view, any reference to the adult content is irrelevant under 401 because it doesn't tend to show that he committed the crimes charged. The court, oh good, let's get to what the court thinks. The court, having considered both sides' arguments, finds the government's motion should be denied and the defendant's motion should be granted. The defendant's 2015 public statement that he developed an addiction to adult content is irrelevant to this case under Rule 401. The government admits that viewing adult content is not illegal, and a so-called addiction to adult content is not a recognized medical condition. The only logical conclusion to be drawn from the government's briefing is that it seeks to improperly introduce this evidence to prove defendant's character in order to show that on a particular occasion he acted in accordance with that character, which is exactly what 404 is propensity evidence, but you're not allowed to do it. The court rejects this notion that an addiction to adult papayas. The chat is kill. I love you, chat. To adult papayas could tend to show defendant's motive, intent, or knowledge to commit the crimes he has been charged with. The court also rejects the notion that the existence of covenant eyes is itself explicable only by reference to the defendant's addiction. They could just explain what covenant eyes is and let the jury decide what that means. The government can present evidence about the configuration of the hard drive, the applications that were running, the names of individuals who purchased, registered, or used Covenant Eyes, and the possible reasons why a user might wish to install it without having to disclose the fact that the defendant previously admitted to an adult pumpkins addiction. The fact is irrelevant to the crimes charged. And the court's like, no, that's what we're not doing. Accordingly, it is ordered that the government's motion to admit prior statements made by defendant is denied, and the defense's motion is granted, which I'm not shocked by. They were really, I mean, sometimes you just got to reach, but the court's like, no, you can explain. And the court showed you exactly what they are limiting the government to. The government can talk about why someone might install Covenant Eyes without having to disclose the fact that defendant previously admitted. And Covenant Eyes really does say it's to help people break potpourri addictions. And because of that, that's literally the point of the program. So a jury can just be like, okay, well, this program's for that, so whatever. I don't think the judge is wrong. I understand why the government went for it. Let's see what happens next. Government's motion to exclude third-party guilt evidence. The government's next motion asks the court to bar defendant from suggesting to the jury someone else might have committed these crimes. Well, the court's already taken the defense position of the government's motion, so that's not going to go well for the government. The court has already said, no, this is what the defense attorney is arguing, and so therefore. The government identifies 3 possible individuals whom defendant is likely to accuse of having downloaded the CSAM on the desktop. The government then proceeds to explain why in detail it believes none of these men could have committed the crimes charged. It is the government's burden to prove that the defendant committed the crimes set forth in the indictment beyond a reasonable doubt. The defendant is entitled to create reasonable doubt in the jury's minds by pointing the finger at others who may have possibly committed the crimes. Oh, there's a footnote. Footnote voice. This does not mean that the court will permit the defense to present speculative testimony or make purely speculative arguments to the juries, which is the scope of that. That's the appropriate scope. The appropriate scope is that the defense can't just be like, anybody could have done it. I mean, anybody could have just wandered into the office that may or may not have been locked and put a partition on a computer and logged into it and then downloaded the things off of the dark web. It could have been anybody. There has to be some reasonable connection, and people who worked or had ties to the car lot is a reasonable connection. It's like, look, these people had access. They could have done the things, and it's the government's burden to prove, well, ladies and gentlemen of the jury, the password is the same that the defendant uses on his bank account. Thank you, the people rest. Because that evidence that we heard at the hearing for the detention is really fucking damning. Because if you combine that with Duggar's statement about trusting felons or whatever that's in the government's previous motions, then why would you give them your login to your computer? So I'm not surprised by this ruling. Let's see. So we went to the footnote. The court will not prejudge the evidence and in the process violate the defendant's right to a jury trial. It is therefore ordered that the government's motion to exclude is denied. Denied. Defendant's motion to exclude improper opinion testimony. The court and everybody agreed, so the motion's granted. Defendant's motion to sequester witnesses. This should just, are we granted? Why is there so much conversation? This is procedurally simple. Oh, okay. We need to, the court grants in part and denies in part. Why is this such an ordeal? Rule 615 provides that upon one party's request, a court may order witnesses excluded so they cannot hear the other witness testimony. Defendant's motion invokes Rule 615 in a specific way, asking the court in advance of trial to prohibit the government and or its witnesses from talking to witnesses who are sequestered about the trial or other witness testimony prior to or during their testimony. That doesn't go that way. That can't go that way. It is not at all uncommon for one party to invoke Rule 615 prior to the start of trial. It is unusual for a party to ask the court to explain the contours of the rule and impose specific prohibition on the party's conduct. This judge is sassy. This judge is like, what we're not going to do is break it down like everyone's for. Guys, get it together. The purpose of sequestration is to prevent witnesses from tailoring their testimony to that of a prior witness and aid in the detection of dishonesty. It just means that when a witness is testifying on the stand, another witness can't be in the courtroom unless that witness is a law enforcement officer, because they already know the whole file anyway, or an expert who is not giving like an eyewitness testimony of this is this and that is that. They are taking all of the information together and giving an expert opinion. This is not hard or unusual. I love that the judge is like, but what is unusual is the way you're asking me to do it. The court, in its discretion, may control the mode and order of examining witnesses and presenting evidence at trial pursuant to Rule 611 and has wide latitude to fashion an appropriate sequestration order for each case. At the trial of this matter, the court will permit the government's case agent to sit at counsel table as the government's designated representative. Always. The same case agent may be called as a witness during the case in chief. Yep. The case agent, and indeed any witness who gives testimony at trial, will not be permitted to discuss the substance of his or her own testimony with any witness who has not yet testified. Natch. That's what always happens. If a case agent sitting at counsel table, why did that come out weird? Counsel table? I don't know where that came from. If a case agent sitting at counsel table were permitted to discuss the substance of his trial testimony or another witness's trial testimony with a witness who had not yet testified, this would defeat the purpose of the sequestration rule. This exact scenario occurred in United States versus Engelman, where the government's designated representative, Agent Huber, spoke to a sequestered agent named McMillan about the substance of Huber's trial testimony. The Eighth Circuit opined that it would be illogical to hold that Agent McMillan, excluded from the courtroom pursuant to a sequestration order, could wait outside the courtroom doors and then discuss with Agent Huber the testimony that they had just given. Given the court's reasoning above, it's ordered that the defendant's motion eliminate to sequester witnesses is granted to the extent that any witness who has testified, including the government's, is permitted from discussing the substance with someone who has not yet testified. To the extent of any relief requested is not specifically discussed here and is denied. So the court's saying what we're doing is following the way the rule works, and what we're not doing is anything weird. Like, we're not going to be weird about it. We're not going to make it weird. Defendant's motion to exclude any reference to defendant's stated decision declining to answer certain questions posed by law enforcement. The government already agreed to this. And the court went over it anyway. In this motion, defendant asked the court to prohibit the government from referring at trial to the fact that he refused to answer certain questions. Specifically, defendant seeks to exclude 10 statements. The government responds that it does not intend to introduce in its case in chief any of the 10 portions of the defendant's recorded interview identified in his motion, but reserves the right to introduce any portions of the defendant's non-custodial interview during cross-examination or in its rebuttal case as these portions may be relevant. Disclosing to the jury the fact that the defendant invoked his Fifth Amendment right by refusing to answer certain questions is both irrelevant to the issue at matter under Rule 401 and more prejudicial than probative under Rule 403. As to the government's reservation of its right to introduce any portion of these statements during cross or rebuttal, the court reserves its ruling for trial and instructs the government, if the need arises, to request a sidebar and make its argument outside the presence of the jury. That paragraph summarizes half the shit that should have happened in the Rittenhouse trial. If the government wants to elicit evidence that is outside the bounds of this ruling, you need to ask me about that shit first. And what you're not going to do is elicit anything about the defendant's Fifth Amendment right, even though there's an argument that Duggar's Fifth Amendment right did not attach yet because it was a non-custodial interview, but that's beside the point. The court's like, what you're not going to do is even come close to a whiff of the Fifth Amendment, even though it didn't really apply at a non-custodial interrogation. But no, if the defendant didn't answer those questions, it still has Fifth Amendment flavor, and you're not going to comment on his silence at all. At all. But if he testifies, the door can open and you can ask other questions. So that's why the court is doing this here. It's therefore ordered that the defendant's motion to exclude any reference to the defendant's stated decision declining to answer certain questions is granted, subject to the court's instruction above. Signed, Timothy Brooks, the judge. We like it. There's a little bit of sass, no shade. We enjoy it. I like this judge. So what you guys are going to be asking about is, can we just live stream the Duggar trial all day with a panel of lawyers to give quippy testimony and talk about what is being seen? No, because it's federal court, and federal court does not allow itself to be streamed. So that's not going to happen. Y'all, it's time to move on to Britney. It's Britney, bitch. It's time. It's time. It's time. I'm just drinking water. I should be swooping and pulling up that motion. The motion's up. It's time to swoop. It's time to talk about Britney. This whiskey disappeared surprisingly quickly, but not given the fact that my face is already flushed, but also, oh, I have sound effects now. Oh. Don't give Emily toys. It's not going to go well. But we're going to use the wah when we finish the whiskey anyway, because it just needs to happen. The whiskey did evaporate, and yes, I did remember that I had sound effects late in the stream. The crowd goes wild. It's time to talk about Britney. If you don't know the whole history of this, it's okay. Britney is no longer under conservatorship. It doesn't mean the court proceedings are over. This was suspicious. Here's what's suspicious. This was filed on November 9th. This was not allowed public on the website until like the 13th. So this didn't go up until after, or the Monday after. This didn't go up until after the court ruled that Britney was released from her conservatorship, which I find very interesting, right? It's just like, it was filed the 9th, but we didn't get to see it until later. So that came down this week. Let's get into this motion. This is a motion from Jody Montgomery's attorneys. Jody Montgomery is currently, well, no, she's the former temporary conservator of the person because Britney's no longer in a conservatorship. It makes me so happy. It makes me so happy. It makes me so happy. All right. You are hereby on notice that on December 8th, this isn't happening because it's already been moved to January 19th. So on January 19th, the temporary conservator of the person shall move the court for an order to seal and limit service of a termination plan. Limit service means not to give it to anyone or everyone. Seal, motion to seal means that, whoomp. I totally forgot to do that. I'll put that up on Twitter. I'm going to have Tech Valor put it in the private chat so I don't forget again. I totally forgot. This is the limit service of the termination plan, meaning they don't want the termination plan to be served to everybody on the service list, and sealing it means it gets, well, exactly that, sealed so that the public can't see it, but also depending on who they leave off the service list. So the person not on the service list can't access and see it. Specifically, Ms. Montgomery seeks an order to seal the entire termination plan, which will be lodged conditionally under seal, concurrent with the filing of this motion to seal to limit service on the termination plan. The termination plan must be sealed in its entirety because it contains information and recommendations based on Ms. Spears's private and highly sensitive medical information, which is fair, which is fair, as well as personal and private information relating to Ms. Spears and her minor children. There can be no public right of access of Ms. Spears's private medical information, which is per se confidential. Moreover, the personal and private information relating to Ms. Spears and her minor children is also per se confidential. I wonder, before we read further into this, if this is going to get into altering her a visitation with her kids and how that gets altered so she gets to see her kids more. And look, as much as I'm curious about things, Brittany's talking about her life on Instagram. I hope that she tells us what's going on in her life. But if this has to do with what changes might happen in her doctors, any medication, if there is any psychiatric care, if there is any, it's okay to seal it. I'm not going to be mad about that. Let's go on and see what else they have to say. Even though some of y'all might disagree with me, we're going to see what it has to say and just go from there. All right. Introduction. As this court is well aware, the petition for termination of the conservatorship filed by Yeated Spears is set for November 12th. The petition is not only unopposed, it is wholeheartedly endorsed by all parties. I want to clap again. Do you see? I want to clap. I want to do a cheer again, but I'm like, is it too much? Is it not enough? Is it too much? Is it too much? Is this too much? Is it too much? Yay. Is wholeheartedly endorsed by all parties. Therefore, it is no longer a question of whether this conservatorship will end, but simply when, which is again language that Rosengart was using. In anticipation of its imminent termination, Jody Montgomery, temporary conservator of the person, worked with her medical team, her being Britney's, to prepare a termination plan to address key issues arising from the transition off the 13-year conservatorship. Since Ms. Spears has been under the conservatorship since 2008, Ms. Montgomery would like to ensure that there are guidelines in place for supportive decision making to help her adjust and transition to life outside of the conservatorship. The termination plan, therefore, necessarily contains sensitive and private information about Spears's medical doctors, conditions, treatment, as well as information relating to her minor children. These are the exact categories of information that previously and rightfully sealed by this court in this conservatorship proceeding. There's no question that this information is not just per se confidential and absolutely protected by various state and federal laws, but it's in Ms. Spears's best interest emotionally and financially. To seal the termination plan away from the prying eyes of the public. It's interesting to me that financially was listed. What's the worry there? I understand emotionally, I understand sealing medical records. I don't disagree with sealing people's medical information. It's nobody's business. If Brittany wants to share it with people, she can. I'm interested as to why financially. I'm curious. In its prior sealing orders, this court recognized the overriding privacy interests of the case. Prior sealing orders in this conservatorship prove the existence of overriding compelling interest, which may have been recognized by the court. For example, in its June 5th, 2009 order, well, that was a long time ago. The order has a very specific provision regarding to the protection of HIPAA-related information and goes through why HIPAA information is protected from court records. It is. Similarly, this court granted Mr. Spears's motion to seal proceedings in this matter on September 18th, 2019. The hearing was sealed due to the consideration of sensitive information about Ms. Spears's children, business interests, finances, and medical condition. And then there's a declaration attached from the lawyer. This court previously held that Ms. Spears's privacy outweighed any public interest in this information. I don't disagree for the large part. Likewise, the termination plan here necessarily includes information derived from Spears's medical data reports and conversation with her medical professionals, including their recommendations for medical and other services, as well as medical and other private information that impacts her relationship with her minor children. All of this information constitutes sensitive information protected by California's Constitution as well as HIPAA. Termination plan must be sealed in its entirety. I'm interested as to why. This court was absolutely correct in its prior decision to seal records in the conservatorship case. Not only does the public have no right of access to conservatorship proceedings, not to all of them, but Ms. Spears's medical and other private information contained in the termination plan are confidential by law. I don't disagree. And while this court is not required to consider anything other than Ms. Spears's per se confidential interests, there is also no question that these overriding interests will be prejudiced if the termination plan is not sealed. There is no less restrictive means to protect Spears's overriding interests. So by that, by less restrictive, they mean just redacting a paragraph or two is not enough. The entirety of the document has to be sealed. There is no constitutional right to access of conservatorship proceedings. I'm not even going to dive into it because I think that the privacy rights override. Medical information is confidential by law. Yes, it is. I don't need the case law on that. Highly sensitive personal information is confidential by law. That's going to include medical mostly, but also anything dealing with her children should be and will be sealed. Ms. Spears's medical and other privacy interests, which are per se confidential, override public access arguments. I mean, I can't imagine a member of the public arguing that they should have access to Britney's medical information and to this plan. They talk about this being narrowly tailored, so there is no other way to do it. Redaction isn't enough. Service of the termination plan must be limited. This is what I'm interested in the most. The termination plan is akin to a care plan, and a care plan is like an ongoing, noted plan that is filed with the court saying this is what we're going to be doing. And it contains planning with regard to Spears's ongoing needs and best interest, just those outside of a conservatorship. It is anticipated that the termination plan will be the last care plan reviewed by the court in this case, as such pursuant to Probate Code 2352.5. It is only required to be submitted to the court through the probate investigator. There is no requirement that it be served to any other party. Footnote 1 goes into the Senate bill. Senate Bill 602 would have required that a care plan be submitted to various persons, including relatives within the first degree, but that bill has become inactive. Interesting. I wonder if it was superseded. Ms. Montgomery intends to strictly comply with those rules by serving the termination plan solely on Ms. Spears's attorney, as with the former court-appointed counsel, Sam Ingham, who we will not disparage at this time, but we reserve the right to do so later. Retained counsel Matthew Rosengart was granted a minute order that, quote, notices for the conservatee are to be directed at Matthew Rosengart. We know this. Did it really need to be a footnote? Did it need to be a footnote? Because I think you need to give it to the investigator too. But anyway, this is getting, I think the crescendo here is she doesn't want Dad Spears to have it. Yeeted Spears to have it. Limited service of such a personal document does not just comply with the rules, but also reflects the wishes of Miss Spears herself. From the history of this case, it's no secret that Miss Spears has a contentious relationship with her family, especially her father, Mr. Spears. Ooh, Yeeted Spears gets a footnote. Mr. Spears has been effectively suspended as conservator of the estate at her request and has been blocked from receiving medical information since he withdrew as conservator of the person. Yeet, yeet. That's not the last three. For all of you that aren't watching on the screen and are just listening to me in your ear, it does not actually say yeet in the document. That was me imposing for fun. Indeed, during the September 18th, 2019 hearing, this court revoked all prior HIPAA waivers, which effectively cut off parties' access to her medical information. I didn't know that. Well, that's nice to know. So in 2019, when Yeeted Spears got removed as conservator of the person, all the HIPAA waivers were revoked. So the only person who had access was Jody Montgomery, which during that same period of time, they were asking to remove Yeeted Spears. It's why they didn't do it is so boggling to me when there was already clearly concern and they had already, revoked his access and limited his access to information about Britt's life. Sam Ingham, Miss Spears' court appointed counsel at the time, stated that Miss Spears would decide who would have access to her medical information on a case by case basis. During the hearing, Ingham also reported that Spears was extremely distressed regarding the media reports that about her and to adamantly opposed the release of the investigator's report to anyone. The New York Times somehow got it now, but um at the time it seemed that she was strongly opposed to it. Mr. Ingham went on to say that Miss Spears relied on confidentiality with the court investigator and would have stopped talking to him if she knew the investigator's report would be seen or used by her parents. Ooh, there's a declaration. Good. Instead, upon request, this court ordered that all medical information go directly to Miss Montgomery as her temporary conservator of the person and Mr. Ingham. Good. I mean, Brittany's been fighting for her family to be out of her life for years, and having them see everything she says about them, I can't I can't imagine. This caught my eye, KB. I can't imagine that she would feel comfortable opening up to someone if they're going to get her reports. Like, how do you honestly say, I'm having a huge problem with this person and know that person's going to read the report? Like, how can you be honest and feel safe? But I digress. Given the history of this case, it's clear that Britney does not want her medical or other privacy rights invaded by her family. Yeah, like bugging her room or any other party in this conservatorship case. In some, limited service of the termination plan is explicitly authorized. I don't disagree. For those reasons, Montgomery requests that service requirement for the termination plan be met by service through Spears' attorney and through a sealed filing with the court only. Conclusion, do what I asked. Can we just do that, please? Conclusion, let's just do this, please. Ms. Montgomery respectfully requests that the court issue an order allowing the termination plan to be filed under seal on grounds that it is derived from and reveals constitutionally, statutorily, and otherwise protected medical information. I don't disagree. They don't want her dad to see it. Ooh, let's get to the declarations. Oh, Lorianne Wright, I declare as follow. I am an attorney. I am counsel for Jody Montgomery. I make this declaration in support of the motion. I attended the September 18th, 2019 hearing. For use with this motion, my office recently attempted to request a copy of the transcript. Oh. The court reporter denied the request because the hearing was sealed. The court reporter stated that she could not provide the hearing transcript unless there was a court order authorizing her to do so. Okay. From my own memory and notes of what occurred at this hearing, which can be confirmed in the sealed transcript, this court granted Ms. Spears' motion to seal proceedings in this matter on September 18th, 2019. The hearing was sealed due to the sensitive information, including, but not limited to, Spears' children, business interests, all the things it said above. The issues to be addressed in the termination plan are confidential. It is virtually certain that in the absence of a sealing order, the confidential information in the termination plan would be circulated on all social media platforms. I mean, hi, we're circulating things on a social media platform. But in transparency and not in malice. Media outlets and be included in future unauthorized documentaries. Oh my, coming for the documentaries. Coming for the documentaries. And in future unauthorized documentaries about Mrs. Spears, thereby revealing Ms. Spears' personal and confidential medical information to her detriment. I wonder if they're salty that the New York Times has the sealed investigator's report, because that's what that sounds like. That sounds like saltiness. But I mean, not wrong. If a hearing was sealed or if the probate investigators' reports weren't supposed to get out and then the New York Times has them and puts them in a documentary, that might be distressing for people. I can understand that. All right, that's not what I meant to do. I meant to do that. New toys. All right. During the September 18th hearing, Ingham, Spears' CAC at the time, asked the court to revoke prior HIPAA waivers. This is just restating what's in the motion because this is the underlying declaration. I don't think we're going to see anything new. Spears was extremely distressed regarding media reports, and that needs to be taken well by the media and heard well by the media. If Britney is going to be able to share on Instagram and share what she wants to share in the way that she wants to share it, that's fantastic. But what we can't get back to is the media hunting her when she tries to go out to get coffee. That's not gonna work for anyone. And with the rise of social media, Britney can put out what she chooses to put out, and that will be enough. Ingham went on to say that Spears relied on confidentiality. At the same hearing, the court revoked all prior authorizations and releases. And I've met and conferred with Miss Spears' attorney, Matthew Rosengart. He has confirmed that unequivocally, Miss Spears does not want her medical privacy invaded by her father or any other party in the conservatorship. Well, whoop, there it is. I trust that Rosengart's representing Britney's actual desires, and her actual desires are some of this shit does not need to be public. She said she wanted to be heard on the 29th. I trust that Britney knows her mind and knows when she wants to have things public and wants things to not have them public. And that's fair. Let's see what Exhibit A is. Oh, I put myself in the wrong spot. There I am. Let's see. These are the orders from 2009. We've been over these in other things. That's the service list. And that's it. And that's it. Yay! We've been through lots of motions today. Lots has happened. I'm sure the world has moved on. We've evaporated an entire whiskey, and it's time for questions. I have questions. You have questions. I'm not mad at the sealing order. I'm not mad about it. You know what makes me not mad about it? The last line where it says Rosengart has talked to Britney and adamantly wants her medical information private. And I don't think it's necessarily the public. I mean, I'm sure part of it is, but I'm sure that she wants to cut off all avenues for her family to get information about what she's doing. And the termination plan can include if therapy, for example, therapy's great. Love therapy. But if Britney's going to therapy weekly at a certain time, not wanting her family to know where she's going to be, not wanting people to know how to access her and things like that. So I'm not mad at this order at all. I'm not. Nope, not mad at it. I understand it. I think it's appropriate. Britney has the right to say she has the right to set boundaries and access to her, and she hasn't gotten to exercise that right, and I'm glad she gets to exercise that right. So, if that means the public doesn't get the termination plan, fine. Do I believe Rosengart when he said outside of court, we have a plan in place, we are taking care of it? Yes, for the first time since I've been covering this, I actually believe that. And I believe that they have her best interest. And I believe Britney to stand up and say, if I want something public, I'll share it the way she did on the 29th. And I think that this boundary is appropriate, and I'm not mad at it. So good. Britney's got access to her Instagram. She's telling people to fuck off. She's getting to show her butt. She's getting to tell people how she feels about sharing her story. She made me cry the other day, like just seeing her say, I'm sharing my truth in her whole voice and being like, rock on. I was like, oh, get it. Get it. And I believe we'll see more and more of Britney on social sharing in a way she wants to and kind of figuring out a new way to navigate. I mean, Britney has not had unfettered access to social media for 13 years. So when she last had access to without scrutiny to her phone, to her life, social media wasn't a thing. So this is also a new environment for her, and it is a lot to learn. She's kind of been Rapunzeled in a tower where she hasn't had access to these things, and it is going to take her time to learn to navigate and to learn to navigate social, and maybe to learn that Jeffree Star was canceled, perhaps, and these things. But she's going to learn that she has not had access to that, and that's not her fault. That's not ignorance. That's not willful ignorance. That's the fact that she was trapped without access, and she's now able to have that. So we should get to questions. I have questions, you have questions, we have questions, and yeah, we have all the questions. So let's go. Questions. Let's go. Yes. Yes, let's go. Questions. I'm going to get to super chats first. I'm going to go through and try to pick up some of the super chats as we get through it. Kathy, I agree with you. She was horribly mistreated. And I think that when Britney was joking about sitting down with Oprah, I hope she does. When you said you had ADHD at the beginning, I cried. Oh, I've been watching you for a while and you're so intelligent and successful. And that gives me so much hope as someone recently diagnosed that I can be successful. You can be successful. Make the world work for you. I get a little salty and you'll see it. I get salty when I'm talking to people who are like, oh, I've been on TikTok and TikTok's like, It's just making me ADHD." It's like, no, no, no. Looking at things that have short time doesn't make you like you are ADHD or you're not ADHD. Our brains work different, and that's okay. Different is good. I like different. But I share, and I always share that I am diagnosed ADHD because I never want people who are just casually swooping by the channel deciding that me and my purple hair and cursey words are not for them. To be like, oh, she's just being like, oh, haha, it's my ADHD. No, I'm trying to share that it that's how my brain works. So if you see that in your brain too, that we can like understand together because there's so many of us in this community that are ADHD and we find it at different points in life and find different ways to deal with it. I watch quite a lot the How to ADHD YouTube channel. I love How to ADHD. I think it's a very informative channel to not just normalize, but also to help. Octonation, who's in the chat, also ADHD, said things to me when we were together in Atlanta that I had never heard before. And it was so me. So I'm just going to share it with all y'all. But he was like, no, Emily, that's time blindness. I'm like, there's a name for the thing. For the reason there would be times in college where I'm like, I'm just going to play The Sims for, SimCity and Civilization and The Sims. But I'm going to play for like an hour. And then like 5 hours later, I was hungry and didn't know what happened. And I was like, wait, what time is it? It's a thing where you actually don't perceive the passing of time. It has a name. I've also been following Shalene Johnson in her journey with ADHD. She was also an adult diagnosed with ADHD. It's a different experience if you're diagnosed as an adult and not as a kid. But Kay, you can do whatever you want to do. You have to make the world work for you. My biggest struggle was getting over the embarrassment that I had about asking for accommodation or telling people what I needed. And there are times when I tell you guys, look, I'm really scattered today. This week has been hard emotionally, and it actually makes it harder to rein in like all of this that my brain does. There's times when my husband, I'm like, I need you to come in the office and work with me because I'm trying to put together like my new soundboard that I was setting up so I could do this, among other things. It's very long. I need a shorter one of those. But I was trying to get the soundboard set up and I was like, "Hun, I need you to work with me to get this done because otherwise I'm going to go to put something away in a drawer. And when I go to put it away in the drawer is going to need to be organized. And then everything's going to come out of all of the drawers to reorganize them. And then everything's going to be in the middle of the floor and I'm going to get overwhelmed and give up. And then this is never going to get done." So I have learned what I need to ask for. So thank you so much for your kind comment. And I'm always happy to share my journey because it's a constant learning process of learning how to be me and how to ask to be me. Kaylin and Emily was a huge inspiration to me when I got diagnosed. Well, thank you. I try. Um, Matt Bond, you're just trying to hurt my head today. And I think it's the patriarchy. This is the patriarchy deciding the value of a wiener and trying to make us all spend more money on them. Uh, so there you go. That's my answer. It was a joke. It was a joke, y'all. Lynn said Brittany is also traumatized. Yes. When Michelle Knight talked in her second book about how talking about stuff helped her and how overwhelmed Freedom First was, but the other victims did recover differently. I don't know the book you're referencing to, but yes, the trauma is real and a lot. Time blindness is hella relatable. Got diagnosed at like 7 or 8. It's real, and it's so hard when you perceive the world differently, whatever it is, ADHD or anything else. Even with dyslexia, it's hard to explain to people what it's like, even with food allergies. It's hard to explain to people what it's like because they don't know, but you also don't know that that's not how they see the world. And this is why I talk about conversations being so important. You don't know how other people perceive the world until you talk to them, until other people share honestly their experiences. And then you're like, oh, you see it that way. I see it this way. I never thought of it that way because we can only see from our own frame of reference, right? So explaining ADHD to my non-ADHD husband is very interesting. And as an adult, I have better words for it, but my kids don't always have words for it. And so I try to translate the three of us in the house that are ADHD to my very patient Dr. B, who is not. And he's like, I don't understand. I'm like, I know, but it kind of feels like this. And he's like, I will try. I'm like, yep. Um, yes, time blindness. The yes. Other people feel time passing. Like my husband's like, "Oh no, since we got home it's been like 30 minutes." And dead ass, it's been like 30 minutes. I don't feel time pass that way. Question, first live stream. Hello, Caitlin Wallace. First question, unrelated but something I'm dealing with. Why, how are HOAs legal? That's a much deeper and longer question than this glass of whiskey has time for. Why are HOAs legal? It depends on the state regulations, and I would start looking at the state regulations. It started with housing valuations, but I would have to look at the history of it. Start with the state regulations. That's where their power comes from. So hopefully that helps. And that is definitely not my area of law as much as like criminal and contracts and pop culture. So, hello, Sloan. I see the chat saying hello, and I would pull up your question, but I don't see it. And I've also been drinking. Ah, there you are. I was diagnosed in college with ADHD. That must have been a weird experience, but also a like, oh, I understand my brain now. Thanks, brain. Which is what I love about How to ADHD here on YouTube, is she always starts with like, hello, brains. And I'm like, hello, my neurodivergent brain likes to do things this way. Um, just diagnosed at 32. Thank you, COVID. I have time blindness too. Got a mantle clock that chimes every 15 minutes to break me out of those blocks. I heavily rely on alarms, but I also have like an A word device that has a physical clock on it where I can see it. But I found that actual like rotary OG clocks help me so much more perceiving time than digital. So I use generally a traditional watch face on my Apple Watch because I need to see it. Um, yeah. So I love this conversation about ADD and ADHD. You guys are the greatest. A fact is a fact, the theater doc, for sure. Um, Not a question, but I remember you saying your kids play Yu-Gi-Oh! A while back. They do. Konami is running tournaments for younger kids virtually on weekends when regular regionals are happening. I didn't know that. I'll go look. My kids have really missed going to tournaments. There is nothing like going to a Yu-Gi-Oh! Tournament. I wish I look. It is a nerd heaven environment. I loved taking the kids to Yu-Gi-Oh! Tournaments when we would get to go play in person, but I'll go look for it because we haven't played since COVID, and it's been something my kids have really been missing because they really enjoy Yu-Gi-Oh! The my kids' perception of numbers and my perception of numbers are different. They are very, very good with that, and I'm amazed that they're able to like deduct hit points and stuff in their heads. I just can't. Margot, do not be hard on yourself. And if you need me to yell at you in my footnote voice, oh, Margot, give yourself a break. Being hard on yourself is not going to help. It is okay. It will all be fine. It will all be fine. Look, at the end of the day, all of us in this room are not James P. Spears. All of us are fine. We're all good. Okay. This is what we're measuring it against. Have you tried to steal millions of dollars from your child? No? Good. You're doing good. You're fine. You're going to be fine. It's all good. It's just, we're all going to be good. So, I'm going to try to get to a few more questions. I send with love. Thank you, Matt Bond. I know I'm either late or 3 hours early. Time concepts are hard. Oh my God, it's Dana. That's me. I also stopped setting as we now, our question and answer session has devolved into a ADHD Q&A, which is fine. For me, I have started scheduling appointments and stuff in the morning because I realized if I have an appointment in the afternoon, Octo and I were talking about this too. If I have an appointment in the afternoon, I spend all day worried I'm going to miss it and I get nothing done. So I need to, if I have to be somewhere at a time, or be on a call at a time, it needs to happen in the morning. Otherwise, I spend all day anxious, and I don't need that either. So, yeah, but I totally feel you. And Ashley Vincent, you're always so seen. Um, always, always, always. Michelle Knight was kidnapped and held captives of 11 years. Oh, she wrote 2 books. Lynn, thank you. I will look at that. I can imagine the trauma in that experience, and I will absolutely look at it. It would be fascinating. Cindy, good question. What determines if a jury would be sequestered? Well, one of the parties has to ask for it. And recently, I mean, in the Rittenhouse case, nobody asked for it. So one of the parties has to ask for it. And after one of the parties asks for it, then the judge has to balance the hardship and the probability of the jury being influenced by the media. I think that was a known high probability going into this case. I think there was room to sequester the jury in this case. I think it probably would have been advisable. I made my chair rocky today, and now it's going to distract me, but I'm here for it. So I think the biggest flaw here is that here's my worry. I can't say flaw because, again, I am not and have never been a defense attorney. I am not and have never had conversations with Kyle Rittenhouse, so I don't know what he's telling his defense team. I worry that the defense team was so confident in their case that they stopped looking at the other things that could be a problem because they're like, no, the evidence is strong. And if they're in an echo chamber, this is the problem with echo chambers. If they're in an echo chamber going, this is a great self defense case, never seen a stronger self defense case, the video shows it all, it's great, it's great, it's great, then you don't even think to sequester the jury because you're like, well, who could ever imagine, who could ever have a question that this is anything other than a strong self defense case? And it's like, a lot of people think differently than that. And if you have those people on your jury already, or have people that are leaning that way, looking at the media every day, you've got a problem. And I think they miscalculated that perhaps. And it's a lot. So question, have you seen BJ's video on this document? I haven't, but I will check. I have not. So Charles says, I am a software engineer. Time blindness is also called flow state or being in the zone. And when writing software, it's desired. It is desired. The thing that is difficult for me is that it doesn't just happen to me with certain tasks. If it was just like a flow state with certain tasks, I love it when it's a flow state with certain tasks because you're just like, oh, we're in the flow. It's great. But when it happens when I am trying to get ready and I'm like, oh, I've got 20 minutes. And then an hour later, I'm like, oh shit, I should have left my house. That's when it gets frustrating. So it can be a hindrance. It can be a superpower. It's finding those little quirks so that you can lean into it when it helps and lean out when you're like, no, but really I have dinner reservations and they will give away my table and then I won't get what I want to eat. Asher said, still finding out new things about my TBI that changed. And I have no idea really changed. Apparently that one has a name. TBIs change quite a lot and can be very, very difficult because you can't explain to other people how you perceive things and you don't always know how your perception changed. So, Asher, it's a TBI is a road and I am so glad you shared that because it is a whole thing. And you're going to keep finding out about your brain because your brain has changed. I've got words said question, did time blindness also affect you in school, like turning in things late? Always turning in things late. Always. Still a problem. Still a problem. Like how many years out of how many years has Emily's car registration been late until she asked her husband to start doing it and things like that. Credit card bills? Oh, fucking hell. I put everything on auto pay, the minimum, just so I don't get behind on things because it's still a problem. Like because it's like, oh, this was supposed to happen 3 weeks ago. Has it really been 3 weeks? Still a problem. Still an ongoing problem. What is the whiskey called that has the Reese's peanut butter cup flavor? It is, and the chat probably told you, Tennessee Legend, I think. Thank you. So I think. Dawn said, dyslexic and ADHD. Thanks for educating and talking about it. I'm in college to be a special ed teacher so I can help kids like me and you. Dawn, that's amazing. We love our special ed teachers. It's it is everything to have that help for our kiddos. I'm going to try to catch up on old super chats and questions. Um, Wolfgang said, I've played Magic the Gathering since before Yu-Gi-Oh existed. It's fun. It is fun. It is fun. What is a traditional watch? That's a very fair question. The mechanical ones with the spinny faces. Dawn said, I don't have ADHD, but my husband and 4 kids do. Oh, so you're the Dr. B of your house. You're the Dr. D at your house. I have recently been struggling with ADHD type symptoms due to mental illness. It's a lot. That's a lot. And it's a lot when you're trying to figure out all the things coming at you. So yeah. Allison said, I feel so validated. I have felt this since childhood in my late 30s, never diagnosed, but makes so much sense. And it's always worth it to go and ask the questions so you can learn your brain better. But I know How to ADHD has a like you may be ADHD if on their channel, and there's lots of resources. So it just is. Thoughts on Oprah interviewing Britney? Sorry if you asked, just got here. We talked about it. I think it would be great. I think what I like about Oprah as an interviewer is she would protect Britney, and then I imagine make sure Britney felt safe and heard, and they could just have a conversation and give Britney a safe, supportive place to tell her story, and that's what she needs. So, I got well behind on the chat, you guys. I'm so sorry. So Golden Green, did you see BJ's video on her highly sus experience at the LA courthouse for Britney's hearing? No, but I have not watched a YouTube video in probably 2 weeks at least. So it's just, yeah, this weekend threw me off. I did practice there. I worked at Stanley Mosque. There's tunnels under Stanley Mosque. I'd love to know your thoughts. I will take a look. I really like BJ, so I will absolutely go seek that out. Since we're confessing here, I'm 39 and deadass cannot read an analog clock. To the point where I once went to a bus at 3:00 and it was 12:15. It's totally fair and then digital for you because the world lets us choose the way we work the best. Michelle said Jim Bob keeps avoiding the subpoenas. Can he be forced to testify? Yes. Eventually, they will find him and serve him. And if you don't show up on your subpoena, if it's a criminal subpoena, you can be arrested. So, oh, this is a good one. Heather Copeland, we're also not Tom Girardi. Yeah, the arrogance of Tom Girardi. Like the arrogance to have $11 million come in for $12 million come in for a client and just like not give it to them and to just take like the arrogance. Most people are like, oh my God, if I misbalance my checkbook, I want to puke. You know, it's just look up Dragon Duels. Yes, we have Dragon Duels. Side Deck is the main shop. I know, running them through Discard. I will absolutely check it out. Thank you so much. Question, COPO, yes, just not yet. We still have time. I'm watching my counter at the top. We still have some time. Yes, COPO, and I need to explain why the fall bracket ran away from me. Question, have you heard of executive dysfunction in ADHD? I have, and it's something I've been exploring. When I got diagnosed, they did not separate us into types, but executive dysfunction is something we work with our kids a lot on because it's part of both of their ADHD. Question, would you consider doing a video about what jurors in a major trial typically go through, how the process works? What is a jury bus? Kay, I don't know how helpful it would be. I'm always here to answer questions, so I will think about it. But I've never been a juror on a high profile case. I've just like been in courthouses with high profile cases, and I've worked with my own juries on my cases. But a jury bus right now, the jurors in the Rittenhouse case, they didn't want the jurors parking at the courthouse and then potentially being followed when they drove home and things like that for safety, which I get. I would park like underground and stay at court late so that I didn't get followed. And even then, there were times we had police escorts to take us home. So the jury bus is actually a bus that takes them well off site to get to their cars so that they can go home safely. Hopefully that makes sense. G dash. So if a jury votes not guilty on first degree charge but hangs on lesser includes how does that affect double jeopardy? The charges that are hung on can still be tried again, but the charges that are decided cannot be hung on, cannot be decided again. So hangs don't trigger double jeopardy. Hopefully that helps. First live, usually replay crew. Love watching you. Thank you, Sarah. Um, I absolutely do a Pomodoro. Sometimes it works, sometimes it doesn't. Sometimes the Pomodoro distracts me, but I love it. All right. I'm gonna try to get to some of the back super chats and catch up on questions. You guys, I'm so far behind on the chat. Um, I was diagnosed with ADHD at 19 after I totaled 4 cars. My mind would wander and I would forget I was driving. That's happened to me. My boyfriend thought I had a brain tumor and took me to the doctor after witnessing it. Jax, I'm glad you got diagnosed. That happens to me. It is something that I am mindful of with my kiddos. I love having a car that drives itself. But true story, today I was, and my tech valor and my editors don't know this because I deleted it and started over, but I was recording something to get to them and I got distracted. And like 5 minutes later, I looked up and I was like, oh, I was in the middle of recording. Damn it. I don't even know what happened, but yes, it does happen. And I'm glad you're okay in those car wrecks. Um, I was diagnosed this year at 32 and have really struggled, especially since I haven't gotten any support from my family. Um, you can find support in other supportive communities. Um, my family is lovely and I love them, but sometimes when people don't know, they just don't know and they don't know how to be supportive. So you've got this. Um, find support groups of people who understand what you're going through. You can find very good support that doesn't have to be your family. You've got it for sure. Thank you, Ashley Vincent. You're the true legend. That's the peanut butter cup whiskey from Tennessee Legend. Thank you, Matt Bond. I also get time blindness playing Pokemon. And new Pokemon's coming out. L maybe Woods. L comma Woods. Question, trying to get my law degree at 32. Yay. And having a really hard time shaking the feeling that it's too old to start a law career. Any advice? I started a YouTube career at 42. I think it's going okay. It's never too late. It A law career is not a one thing. There's lots of impact to be made. Decide where you want to make that impact and go in that direction. Your law career doesn't have to be a first year partner, be a junior associate, be a, name partner, be a, percentage partner. It doesn't have to be like that. You get to pick what a law career looks like for you. And there's lots to do within the law. There's lots to do in research and writing and advocacy. There is so much a law degree applies for. Don't look outside the box of your traditional law career. It is never too late, and experience matters. So does having context, because you get kids in law that have never worked, like, ever. They've like gone to school, they've gone to law school, their parents have paid for them, they get a law job, and they don't understand when people come to them and are like, these are the hardships I'm experiencing. How do you help? They're like, well, why are you doing that? It's like, have you not lived? Oh no, you haven't. So don't ever give up. I love seeing the chat being so supportive. Um, Ari T, this is a great question. And if the chat knows, I would like to know. I don't know if Diane Sawyer ever apologized, but should have, right? Should have apologized. How do mandatory subpoenas not violate the Fifth Amendment? Because if you're not charged with a crime, you generally don't have a Fifth Amendment right. So if you've done nothing wrong, you can be forced to testify because you're testifying not against your own interest, but testifying against somebody else's interest. And so therefore your Fifth Amendment right doesn't apply. But people can plead the Fifth, but then generally there's a hearing of like, what do you think you did wrong? What are you pleading the Fifth to? Like, you can't put somebody on the stand and be like, so tell me all the illegal shit you've ever done. But if it's like somebody coming to testify that they witnessed something and they haven't had any part in it, there's no Fifth Amendment right there. So only against self-incrimination, not against never speaking under subpoena. Theater Doc, we did have a Chenandolar Bing. There was a Chenandolar Bing and a Chenandolar Bong because we're at 174. Guys, we're still plowing towards 200K by the holidays. Should we make it Bing? I'll check down in the chat once I catch up and see if we make it Bing. I love this, Daria. I love our chat. You guys get me. And you're like, no, your brain works like mine. Yes. What's your opinion on Team Con trying to get the documents sealed for Britney? Um, I don't think Team Con is trying to get the documents sealed. I think Rosengart has approved of that, and I don't have a problem with medical documents being sealed. I really don't. I think medical documents should be sealed. I don't want I, I don't want anyone to feel like they can't be safe in their treatment if they feel like that can be known. And I think the thing Brittany probably needs desperately is a sense of safety and a sense of autonomy and a sense of protectedness. I guess that goes with safety, but not having her dad know all of her business, I think will help her feel very safe. Meriden, thank you for this. I got my law degree and passed the bar at 48. It's never too late. Law nerds are the best. I've been dyeing my hair to cure depression, but love hearing the mental health talk. I couldn't be diagnosed ADHD, but I have some similar issues. Fantastic. And sometimes a haircut or a change of color is all you need in life. Um, I'm so happy to see you live to thank you in real time for all the impressive and informative research. Well, thank you. And coverage of all things important. P.S. Brittany should not afford Oprah the pleasure and prestige of her story. Okay. I mean, I have no problem with it. We're going to have to Larissa said Rosengart said medical, not its entirety. The entire plan from Jody Montgomery, that whole plan from Jody Montgomery is the medical plan. That's all Jody Montgomery's in charge of is the medical plan. So it's just going to be emergency plan, her plan with her doctors, all of that. So that's it. Moonchild, why seal it completely? Because they said that it was the least restrictive method. The entire plan is going to be medical. So I don't know if they can meaningfully redact it or if they'd have to redact everything. So, what do you call something stolen from the court? A 5-pinger discount. Ayo. I hope I hit the right one. So Nate said something today. If you're explaining, you're losing. What's your opinion on that? I don't have context for what Nate said. It depends on the circumstance. I mean, when you're explaining jury instructions to the jury, you're generally winning. When you're explaining things to the judge and the judge is nodding along and listening and starts repeating your words back, you also win. So context is important. I don't know the context. It just depends on context for sure. Thank you. I know. Brittany should be on your show. That's a safe place. I mean, it's definitely not Oprah. It is a safe place. I don't know. Any internet with a chat, we try to keep ours a very safe place, but any internet with a chat might not feel like a safe place if you're Brittany. So I don't know. All right, let me go to the old ones. Question, does Rosengart talk to Brittany in person? Not sure. It would either be in person by phone or by Zoom. I'm sure because they're all in LA and I'm sure they've met in person at some point and would have to have those conversations. And especially after the allegations of her room being bugged, I imagine that Brittany would feel more, I would feel more safe to be able to sit down in person and talk to someone and explain where I'm coming from and say, this is what I want, this is what I don't want, and get a sense for that person. And sometimes you just need to do that in person. So Brittany follows me on Twitter. No idea why, but so cool. I'll tweet her go at Erica. If Brittany wants to come on to YouTube and have a conversation, her lawyer would probably say no, but I would absolutely say yes. We would celebrate it. Hold on. I've got to go tell YouTube to not suppress my video. YouTube, we said potpourri. We said adult potpourri. We knew it was coming though. Like we knew that was going to happen. That was early predicted. Let me get to some of the old super chats that I missed. Thank you guys for being so supportive. Thank you guys are chatty tonight. I'm here for it. I'm chatty tonight. I shouldn't be. I should be packing. I should be packing. I should be packing. Belly said, what are your thoughts on the judge in Rittenhouse allowing the jury or jury member to take the jury instructions home? I touched on it at the beginning. I've never seen it. I've never heard of it. I think it's crazy. I don't even know what's happening there. I've never even heard of that being okay. Like, I don't like it. I sound like my grandmother. It's like, I don't know what's happening here. I don't like it. I don't understand. I just know. Enchanted Wing says passion, orange, and mango. That's not pog juice because that's passion, orange, and grapefruit, but passion, orange, and mango cold brew tea. Great to see you tonight, 1 a.m. here. That sounds delicious. We love cold brew. I'm contemplating, as you all need to know everything about my life, I'm contemplating buying a new coffee maker that also does cold brew. And I feel like I need it, but I don't. But I do. But my coffee maker works perfectly fine. But if it goes on sale, I think we're just going to do it. The public health gal says, Emily, I love your cut and color. You look beautiful as always. Thank you. It needed a trim. Like the ends were getting to be a little much. We definitely needed it. So it feels light. The color is fresh. I love the white stripe. It's a vibe. Like my hair entertains me. And isn't that what hair is for? Celine, good to see you drinking Mezcal IPA. I love seeing what IPAs you're drinking. Rachel said, my first live watching with my new kitten. I think we said hi to Lucy Ricardo. Brandy Rose said, question as a prosecutor, did you ever have a case where you didn't think the defendant was guilty? Yes. I'm thinking of the Rittenhouse trial. And if so, how was that to navigate through? I stomped into a boss's office on more than one occasion and was like, this is not what we're doing. I also had cases where I'm like, what we shouldn't be charging is all of these charges. I also had cases where I'm like, what we should be charging is everything. So there were probably more often times where I wanted cases to be charged that we didn't charge than there were cases charged where I didn't agree. Those were very few and far between. And I fought like hell to either reduce them or find a just result where I'm like, okay, I get that technically they might be guilty, but like morally it's not. It's not. So let's fix it. And that's the thing about being a DA. You have to stand up with your gut and be like, this is bullshit. We're not doing this. There was a case with a motorcycle accident where a woman had turned left and there was some question of how far in front of the motorcycle she was when she turned left, and the motorcycle drove into the side of her car and he went over her car and passed. And so there was a lot of reconstruction on it to be like, how far is reasonable? And was the motorcycle speeding up into her car or did she cut them off? And we reconstructed it. We brought in witness testimony and I'm like, this is tragic. Somebody has died, but this was an accident. This was just an accident. I think she was turning left against a yellow. And technically, when you're turning left against a yellow, you're responsible for making sure oncoming traffic's clear. But also, somebody on a motorcycle was zooming up to get through the yellow. It just, that's not a vehicular homicide. It's just not. And so, yeah, I stomped my little last season Prada shoes into their office. That's a lie. Prada is really narrow and I have giant feet, but I stomped my DSW shoes right into my boss's office and gave them a piece of my mind about that case. And they let me get the reconstruction going on it. So that's what we did. Thank you for the question and the tangent. Nico, love the gray streak in the front, Emily, giving me Rogue from X-Men vibes. Me too. And I love it. I had a gray streak that wasn't quite this prominent and we decided to just bump it out for funsies. Because why not? Because why not? All right, I lost where I was in the super chats. I'm gonna go find it. Where did it go? Okay, Brandy, thank you for your question. Paper Cranes said, wanted to pop in and thank you for being open about your ADHD. Seeing how you talk about it has made me reflect on how I treat myself during ADHD moments. I've started being a lot nicer to myself as a result. Paper Cranes, don't come into my chat and make me cry. I love that comment so much. Thank you. That's very, very kind. And therapy works. Therapy's hard, but therapy works. It takes time to learn how to be kind to yourselves. We're always so hard on ourselves. Jessica David said, I've started saying we're professionals here in meetings at work. Hope you have a relaxing weekend, even with travel, get some meaningful rest, going to try. That MF Wolf said, have you tried mead before? We've had that discussion. No, but need to. On Terra XOXO, ooh, your hair, thank you. I doubt my parents are watching, but if they are, um, my mom is going to hate it. I will see her tomorrow and she will tell me that she hates it. She's going to hate it. I'm sorry, mom. I love you, but it's my hair. Um, and I'm in my 40s. Kimmy Sparkles says, "What are the odds that Britney will actually be able to hold those accountable for the last 13 years? This is a choice for her. I am not going to hold out too much on this choice because I understand if Britney says, fuck you, fuck you, fuck you, you're cool, I'm out, and just walks. Or if Brittany says, I don't care how much money it takes, somebody's going to jail. She gets to make that choice with Rosengart on how hard she wants to push and how much money she wants to spend to push. Because at the end of the day, this is all a financial consequence, but also it's an emotional drain. So that is going to take some decision, hopefully with her care team of, do I want to continue to fight? Do I feel good about fighting? Do I feel supported in fighting? And or will fighting be detrimental? And am I gonna slam the door shut, bolt it, and walk the other direction and just say, that is the past. This is a new chapter. What's done is done. I don't want to go back. I don't want to fight. I want to walk away. And this is a decision people have to choose when they're going through criminal prosecutions, if they're victims of crime, that people have to go through when they are civil litigants. At what point do you say, I want to heal, I don't want to fight, and I don't want to spend the money to fight, and I'm done? It's a choice. So I hope she has support in making that choice. I don't think we'll see that choice made quickly, but we'll see what comes up in new court documents and if there are more down the line, what happens. Pound Sand said, I found it hilarious that the prosecution reamed Rittenhouse for having an AR-15 to protect himself while trying to give aid to people. Then the prosecution called Groskowitz a hero for what he did, commended him for his tattoo that said, do not harm. And the first thing Groskowitz did when meeting Rittenhouse was to pull a gun on him. I mean, Groskowitz lied about having a gun. I think that's going to be damaging to his civil case. He also, of the two, Groskowitz had an illegal weapon and Rittenhouse had a legal weapon, which I know people are like, that doesn't make any sense, but that is the law. Rittenhouse's gun was not illegally possessed. Groskowitz's was concealed and he did not have a concealed carry permit and it was illegally possessed. It's a very strange turn indeed. Miranda said, CNP word hung to refer to juries that cannot seem to agree to match most closely to the meaning of the word hung as caught, stuck, or delayed. That makes sense. Thank you. Natasha said, I think this prosecutor's prior cases should be looked at because of his misconduct. In this case, he seems like a sketchy prosecutor, IMO. He does seem like a sketchy prosecutor. I don't like it at all. I don't like what I've seen from this prosecution team at all. And then let's see. Meriden said, loving your input on the Ricada streams. Both the defense and prosecution are infuriating. Even as a baby lawyer, I can see way too many mistakes, carelessness, lack of advocacy, and efficacy violations. Yeah, and ethical violations. It's been a lot. And I think that because it's on film, there will be people who do studies on this case, no matter what happens, because it's all on video and it can be done. Faith and Plans, do you think the prosecution is so awful because they don't necessarily support their own case, or are they really that bad? If they didn't support their own case, there was no reason to not play by the rules. If they're like, you know what? Give it to the jury and let them decide, then you're not violating the Fifth Amendment rights. You're not playing games with evidence. You're just giving them the case and letting the jury decide and saying, look, they have a right to a trial. We're here doing a trial. I think the evidence fits. You all decide. That's not what they did. Oh, and somebody's correcting me that POG is pineapple, orange, guava. Yes, accurate. I was wrong. Is it passion, orange, and guava? Either way, I trust the chat to sort it out, and I trust you to be more correct than I am. So Joanne M asked, have you ever prosecuted someone you thought not guilty? No. I've had cases like that I've gone to my bosses and resolved. Charles Vance said, I'm a new sub. Enjoy your opinions while watching you on Ricada Law this week. Thank you. Brandy Rose said, I super chatted a couple weeks ago, but I'm a 3L Patreon member and haven't received my Tumblr. I sent you a DM on IG. I'll go look for it. Hoping for some news soon. All of the shipping information should have gone to your email, but Brandy, I will go look for it. I have been out of my DMs for like a week. So I will go and look into my DMs for it for sure. You can also email help@EmilyDBaker, and we can definitely check on it. Matt, the future ESQ. Hey, Emily, you have been a very bad influence. Sorry. I need the gold Apple Watch with the Rittenhouse case is going to be used in law school as a case study. Yes, and yes, and yes, the gold Apple Watch is delish. Susan said irrelevant, but I love your shirt. Where can I get that? Who are we? Probably Target. This, I'm guessing Target from their workout line. Yeah, I needed more long sleeves when I moved to Tennessee, and I have very short arms. So when I buy things with thumb holes, then it can excuse the fact that my arms are short. Not a good look for a water polo player. Short arms. Avalma said, what is the line between sealing a document versus redacting private portions? It's the least restrictive means necessary. And in this document, they argued that sealing it was the least restrictive means necessary because all of it's going to be medical or related to her kids. Jay Thompson said, while we may want to see this info about Brit, we need to be careful of our feelings of entitlement. Could make us just like Jamie. We only have the right to what Brit wants us to have. Agreed. I've got words. Ingham, oh, we did that. Ingham doesn't need her medical info. You don't think he wouldn't raise a concern and try to get her back and make $10K a week all over again? And nobody needs her medical records, but Ingham has no right to them. He is no longer her lawyer. So Rosengart is her lawyer. And now I think I'm caught up. I'm going to do 2 more and then I've got to go. We're like right at 2 hours and I've got to like, let me pull this up bigger so I can read it. Coburn said, explaining it was during the Aubrey case this morning. Okay. One of the McMichaels was testifying. So I guess on the stand, but I also kind of looked at it as argument. Also, maybe I was wrong to assume though, if someone's on the stand and they're having to explain over and over and over and their story's not making sense, it's not good. So context. Yes. Thank you. Context does help very much. Question. Do they bleach your hair first for the purple or use a dye specifically for dark hair? No, I do not bleach. I've lightened strips of it. So you'll see strips that are darker that Garland's use lightener on. This part got a little bleached, but with a very specific bleach to match all the gray to just bring it all to the right color with a little bit of a shadowy root. And the rest of it is just purple color over my hair. I will have to ask him exactly what color we are or exactly what we are using. Oh, we need to do COPO. I totally forgot. I chose violence for this COPO. So just so you know, Nate was talking about Travis McMichael's testimony under cross about discrepancies from statements to police versus in court testimony. Well, yeah, in that case, if you are trying to explain the differences in your statement, it's not going well for you as a witness. Your statements should be fairly consistent. There are normal inconsistencies, and then there are like gross inconsistencies. Do you think there's a chance of James Spears ending up in prison for an extended period for this? It depends on what they find. I don't have enough information yet to make that determination. It depends on what they find. So if there's malfeasance and misfeasance, then we'll see. Jennifer K, thank you for making my Friday evening fantastic. You're welcome. Hopefully it's Friday where you are and I haven't confused you by being live on a Thursday. I also get days wrong. All right, we need to go to COPO because we haven't done it and I have to apologize. Look, I had all good intentions of doing a full bracket for Halloween, for the Halloween movies. And then Twitter wasn't working on polls. And then I got completely off track. And then I got behind. And then I got embarrassed that I was so behind. And then I was like, oh my God, I'm so behind. And now I'm like, we can't do it now. It's the end of November. So we're going to save it and do it next year. So for everyone that was invested, I'm glad you were invested. I'm sorry. That was completely me. I was just like, I did it badly. I'm sorry. When I share the court doc, I will share a link, a drive link, and I will put it on the community tab here, and I will put it on Twitter. That's where I will put it. So if you don't follow me on the Twitters, you can go do that at the Emily D. Baker. I mean, maybe if I have enough Twitters, they'll verify me so people stop trying to be me on Twitter. And probably not. And then on Instagram at the Emily D. Baker. And we should do COPO. So get ready. We're going to just, it's time. It's back. I've missed it. And law nerds, this one's going to be hard for you. Just brace yourselves. I like that intro. Um, y'all, here's the question, and this is something that's playing out in my neighborhood. When do you put up your Christmas tree? Like, when do you put up Christmas tree? Like Christmas tree slash Christmas decorations? Is it, you know, right after Halloween? Is it right after Thanksgiving? Is it in December? When is it year round? When is the appropriate time to decorate for Christmas or the holidays if you do not celebrate Christmas? But what is the time? When is the time? Because we're gonna put up a poll so you guys can vote on it. But when is the right time? Because this is something people feel very strongly about. And people putting up their Christmas decorations in October stress me out personally. But I want to know if that's you, or do you when do you do it? Um Carrie asked a question about the Duggar trial. Do you think Josh's sisters will have to testify? Oh, it depends. I don't know how the court hasn't ruled on that yet. So once the court rules on that motion in lemonade, once the court rules on that, then I think we'll have a better idea. So possibly, but also it could come up at sentencing. So there's two ways that this can come up. And if he's convicted, this can come up at sentencing. And if it becomes relevant, it can come up during trial. I'm doing lipstick and not lightsaber lip gloss today because I love this color so much and it's super hydrating. You guys know how I feel about my Gerard Cosmetics, but this is Rodeo Drive and it is just, look, what you don't consider when you change your hair color is that you have to change some of your makeup too sometimes because it looks different. So court is in session day after Thanksgiving. Oh, I didn't explain very well the court of public opinion. Court of public opinion is for fun topics that, we all can disagree on, but we get to defend our positions. So for all of you that are like day after Thanksgiving, it feels so early. Day after Thanksgiving, I just want to sit and play video games with my kids. Did I bing twice today? I think so. Were we at 172 yesterday? I think we were. I don't know what's happening. One of my trees is up now. See, Kelly, you're either a genius or you're the problem. Or you know what? For people who love Christmas, I can see being like, put them up. I want all the sparkly trees. I have friends that decorate trees for Halloween and then change out the ornaments to do like the Nightmare Before Christmas Halloween themed tree and then shift it into a Christmas tree. So, whenever you want. See, Samantha, it's totally fair. And I feel like it's just like, oh, what are you people doing? Why is it a thing? Yes, it's a thing. And Hanukkah's super early this year. And starts very, very early. I was taken aback. I was like, wait a second. I see this on my calendar. Early. So what about brackets for Christmas movies? I don't know if I want to bracket a Christmas movie. So we've got the poll up and running. Go ahead and vote. We'll close it. Black Friday resident MILF. Where's the never option? I mean, I guess not voting. Maybe. Jacqueline, I like your hair tonight. It looks nice down and parted to the side. I love a side part. And thank you. It's because I was at my hairdresser yesterday, but also the cut has helped. So when it's curly, I'll post it this weekend. I'm going to curl it because we're going to a wedding. So I will curl it up and you guys will get to see all of the dimension and the color. There's like 4 different colors in here. I just love it. I love it. So whenever family's around, usually Thanksgiving, that's fair. Doing it the last weekend of November, fair. First weekend of December. Why is never not an option? I mean, does never need to be not an option? Should it be? Because we can change the options. That's why we do COPO here. So we can change the options before it goes to the social, before it goes to the interwebs. So we can do never as an option. I've seen a number of you ask for never. So our options right now are after Halloween, after Thanksgiving in December, we could do never. We could just do a never. I think we can change it to never. I like it. I put mine up today because it's been a long year. That's fair. And the twinkly lights make me happy. There are 12 days of Christmas. Well, yes, but when do you put the tree up? On day 1? Is that what it is? I hate that November gets overlooked. I do too. I love my Halloween decorations and I have quite a lot of blown glass pumpkins and I leave them out all through November. I love having the blown glass pumpkins out. Black Friday instead of shopping. I love internet Black Friday shopping before Black Friday. I do not like going out to the people on Black Friday. Um, should have reminded of the chat rules before this one. Emily's out here stirring the interwebs. Emily chose violence. Yeah, we're gonna add. I will add never as an option before I put it up on the channel and before I put it up on Twitter for sure. Australian, a lot of people are doing it in November, but I wait until December because toddlers. I admit that's also fair. This is so Fred and George are January kitties, which is an unusual birthday for a kitty. So they're almost a year. So I don't know. We haven't had kittens at Christmas time in a really long time. So we're gonna have to modify. We're gonna have to modify our Christmas plans or our decoration plans for the cats because because kittens. Immediately after Thanksgiving, sometimes evening of, which is fun. COPO example. Yes, thank you. COPO means court of public opinion. For those of you that are like, wait, what are we doing? King Quinn, yes. COPO started with a hot dog as a sandwich, and it's been a thing. And that just happened because we were chatting in the chat during questions. And this is Ashley, this is a very valid reason to start decorating. Jennifer said never before Thanksgiving, give each holiday its time. Yeah, that's a fair point. I like Thanksgiving, but I also like having small Thanksgiving. I do. After Remembrance Day, November 11th here in Canada. Thanks for all the coverage. So Remembrance Day is our Veterans Day here, November 11th, because it's Armistice Day, I believe is what it's tied to, if I'm remembering properly after drinking. But yes, I like that after Armistice or after Remembrance Day. Emily woke up and chose violence. Yes. But the correct answer is after Thanksgiving, y'all follow the calendar. I mean, it's like December. Stuff happens in December. That's fair. Trisha Lynn, right? We love a good blown glass pumpkin. Love it, love it, love it. It depends if the tree is fake. That's fair. We have fake trees in our house. Don't judge me. We have fake trees, and then I have a diffuser, but sometimes the trees give my little ones allergies. So, Emily, what you need is a fat old Labrador. Ours keeps the 4 cats and birds in check. Queen Oogie Boogie. I love Oogie Boogie, and that's not a bad idea. We do not have a dog at this house, but it might need to happen. Right now, I can't have any. Look, the distractions while streaming are enough. It's going to take some time before we do that. I will be talking, Nick. Yes, I will be talking about Tiger King 2 next week. I need to watch it. I want to talk about the legal situation of not just Joe Exotic, but also of Carol Baskin. And Carol Baskin, the judge let her file, and then the judge was like, I'm taking it under advisement and just let the date pass for this to be released anyway. And the judge was like, nah. Shit's out of the horse now. It's too late. It's been released. So I am going to be downloading that onto my iPad to watch on the plane because I want to talk about the law stuff. You guys are like, don't bother watching. I will watch because I want to talk about the law stuff. I don't mind bad TV. I mean, you all know I watch a lot of bad TV. I embrace it. I want to see it. But I sit next to my kids on the plane. I might not be able to watch it. Well, we'll see. I also have some books I want to listen to. Plane feels like downtime. It's like put on the noise canceling headphones and just like be zen. Okay, y'all, I appreciate you. We need to end the poll and see what the poll says. And then we need to add an option for what was I going to say? For never. So when it goes to social media, I'll add an option for never. And we'll do that. Thank you, Lonards. Let me go see what the poll results are. After Thanksgiving, 57%, in December, 28%, after Halloween, 12%, year-round, 1%. I mean, that's fair. So, y'all, thank you. Thank you for being Lonards. I will miss you on Friday night. Have a wonderful Friday night. Mods, have a wonderful Friday night. Thank you for being here tonight. I appreciate you. Lonards, take care of yourselves. I guarantee you some shit will happen while I'm on a plane. If you follow me on social media, I will share there when I am off of a plane. If I need to do a YouTube short, I'll do one if stuff pops off, but I don't plan on recording this weekend because I am going to be away. So enjoy. I appreciate you. Thank you for being a law nerd. Cheers. I will see you soon. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.